law firm fee agreements. And again, the risk shifts progressively from client to law firm. From the hourly, really low risk for the law firm, high risk for the client. They got to pay out of pocket every month. Contingent, opposite. The law firm takes a lot of risk. There's also these hybrid fee agreements. You can have flat rates with smaller contingencies. And the key here, though, is what do you do in situations where the proceeding itself is going to be hybrid? I can tell you right now, we have 12 lawyers in our litigation boutique. We're all commercial litigators. I am a patent attorney. We have patent attorneys, but I have primarily, all my practice, have done work in court. I have not really done anything in the patent office. So it's not fair for me to say, yes, you know what, I can represent your interests in the procedures in the patent office. I can argue for you as litigation counsel, but I cannot do that. And so when you have now a world where you've actually melded two proceedings, your fee structure probably has to be kind of congruent with that, in my opinion. And so these are the types of fee agreements that we've actually employed in this past year for various different clients with IPRs involved and also on the litigation side. We've done flat fixed, we've done cap, we've done contingent, we've done partial contingent, we've even done defense contingent. We represented alleged infringer. We're taking a defense contingent, holdbacks, discounts. Now that the access to the court systems is taken care of, the next point that needs to be really discussed is what are some best practices dealing in this world? The first thing is litigation counsel needs to come up to speed on IPR procedures. When I told you earlier, when we were doing inter partes re-exam, I kind of left it to the patent prosecutors to deal with. I can't do that now. And the reason why is because the risk of the IPR, the cost, the fee structure, and all that kind of stuff need to be discussed up front. When those are discussed up front, you need to start coordinating with your IPR counsel as early as possible. So for example, if Chandra and I were going to co-counsel a case, we have to discuss, if I file a lawsuit and defendants then say we're going to file an IPR, well, how are we going to coordinate discovery? How are we going to coordinate depositions, experts? We want to minimize the costs. Converse is also true on the other end too. If I'm representing a defendant and I want to choose an IPR counsel to help me, I want to try to minimize my costs in doing that. Admission to IPR proceeding is pro hoc vici. I'd have to be admitted as pro hoc vici. The lead attorney has to be a registered patent lawyer. There's procedures for that. Although I could probably do that, I'd rather be pro hoc'd in and let my IPR counsel handle the day-to-day stuff. And one final issue I'm going to address about is the term prosecution bar, if everyone's familiar with that. In litigation, we enter into protective orders, which basically allow us access to confidential information from the other side that we can use to prosecute the case. And most sophisticated defendants will put what's known as a prosecution bar in there that disallows the litigation counsel to have access to that confidential information and then go off to the patent office and file new claims on maybe new technologies that are being developed. Typically, there's also a carve-out section for that, and we'll talk about that. And one of the latest cases that just came out, I guess in this summer, with respect to the prosecution bar as it relates to the IPR procedure was the Prolecta case out of the Eastern District of Wisconsin. And this issue was just very simple, whether a prosecution bar and litigation protective order prevented the patentee's litigation counsel from participating in a subsequently filed IPR. Sounds simple enough. Well, what the defendant first did was it actually went to the PTAB, to the Patent Trademark and Appeal Board, and actually moved there to disqualify litigation counsel. The board actually issued an order that said, you know what, this is actually a judicial type proceeding, so we need litigation counsel here. If you want to determine the scope of your protective order, go back to the court that issued it. And so, what did the defendant do? Well, they went back to court. So they went to the court where the underlying litigation was being conducted. And this is what the provision of that protective order said. It said a person for a receiving party who acts as confidential attorney's eyes only materials shall not, and I'm just going to skip to here, draft, supervise, assist, or advise in drafting or amending patent claims or patent specifications. That's all it said. It didn't talk about during re-examinations. It didn't talk about ex parte, inter partes review, post-grant review. It didn't talk about anything. It just said that if you have access to confidential information, you can't draft claims. So what did the court do? Well, it sort of said yes and no. And of course it would split the baby on that one. And here was its rationale. Court said the plain language of that protective order was a prosecution bar. I mean, it's simple. There was no carve-out. So then the next step is, under the In re Deutsche Bank case, is there an exemption for this litigation counsel? And the two tests are if the representation to the PTO does not implicate competitive decision-making, and whether or not there's injury to defendant outweighs injury to patentee. And the court said no. But, and here's a big but, the court also realized that the IPR, just like what the patent board said, is not a purely examinational proceeding, and the intent of that act actually was to make it an adjudication. So the patentee would be prejudiced if it's litigation counsel that has the skill sets for arguing now in front of the board with litigation expertise was disqualified. So the litigation counsel could still proceed, but they'd have to be firewalled off from amending claims. Now, I asked Chandra this last night, what is the practicality of that? How does that work exactly? I'm not even sure, okay? So that, in that simple situation, it means that I get access to all the confidential information. I get to work with Chandran, but I have to keep my mouth shut. When he goes, what do you think about this claim? I don't know how that works. That's going to be fun to watch. So what's the takeaway? Carve out early. So if you're a litigation counsel, make the carve out for yourself early. If you need to go to court, fight it first before you have a situation like this on the practicalities of something like that happening. So that's about all I had. And I guess we'll skip questions and stuff like that. And I'll turn it to Chandra, and he'll give the more of the IPR side of things, and then we can have discussion afterwards.
Yeah, please.